She was still groggy from the anesthesia when he placed the pen in her hand. He told her it was routine, just paperwork for the estate plan they had discussed months ago. She remembers signing her name. She does not remember reading a single word. 18 months later, Patricia Ann Mercer sat across from a bank manager in Phoenix, Arizona, asking why her retirement account showed a balance of $14. The account had held $1.8 million the week before her surgery. The bank manager slid a document across the desk. It was a power of attorney. Her signature was on it. She had no memory of what it actually said. Patricia Ann Mercer was 62 years old when she lost nearly everything she had spent 4 decades building. She had taught 4th grade at Desert Vista Elementary in Phoenix, Arizona for 31 years. She had raised 2 children as a widow after her first husband passed away in 2009. She had saved carefully. She had invested patiently. By the time she retired in 2019, she had built a retirement portfolio worth $1.8 million through decades of disciplined contributions. She had met Gerald Voss in 2017 at a financial planning seminar she attended to better understand her retirement options. He was a licensed financial planner, warm, patient, the kind of man who explained complicated things slowly and never made her feel foolish for asking questions. She married him in 2019, the same year she retired. For the first 2 years, life felt full again after years of being alone. Then, in March 2021, Patricia underwent a major spinal surgery to address degenerative disc disease that had been worsening for years. The recovery was harder than her doctors had predicted. She spent 11 days in the hospital. She came home dependent on pain medication, a walker, and her husband for nearly everything. Gerald handled her medications. Gerald handled her appointments. Gerald handled, increasingly, everything. She remembers feeling grateful. She does not remember the exact moment gratitude became dependence and dependence became something else entirely. There were details that, looking back, she wished she had questioned while she still had the strength to ask. The way Gerald began answering for her when doctors asked how she was feeling. The way her phone calls from her daughter became shorter, always with Gerald nearby, listening. The way every financial conversation now happened while she was tired, medicated, or freshly out of a procedure. She told herself she was simply healing. She had no idea how much was disappearing while she did. Gerald Thomas Voss was 58 years old and spent 26 years as a licensed financial planner in Phoenix, Arizona. To his clients and colleagues, Gerald was measured, professional, and reassuringly knowledgeable. He specialized in retirement planning for clients over 60. He knew, better than almost anyone in his field, exactly how vulnerable a person becomes after a major medical event. He had married Patricia in 2019 for several reasons. He genuinely enjoyed her company. He also recognized within the first year of dating her that her retirement portfolio was substantial and entirely under her own control. Gerald had accumulated significant personal debt from a failed independent advisory firm he had opened in 2015, which collapsed in 2018 after losing several major clients during a market downturn. He owed $430,000 across several business loans he had personally guaranteed. He had never told Patricia about this debt. When Patricia's surgery was scheduled in February 2021, Gerald saw an opportunity he had been quietly considering for months. 3 days before her surgery, while discussing preoperative paperwork, Gerald included a durable power of attorney document among the routine hospital forms. He told Patricia it was standard medical preparation. in case complications arose during surgery. She signed it without reading it, 20 minutes before being taken into the operating room, while under preoperative sedation that her own medical chart would later confirm had already been administered. He had chosen that exact window deliberately. What followed unfolded over 18 months with the precision of a man who understood financial systems intimately. In April 2021, 3 weeks after Patricia's surgery, while she was still recovering at home on heavy pain medication, Gerald used the power of attorney to transfer $400,000 from her retirement account into a joint investment account he controlled, characterizing it internally as spousal retirement consolidation. In July 2021, he transferred an additional $320,000, this time directing the funds toward paying off his own outstanding business loans from his failed advisory firm. By December 2021, Patricia's home, fully paid off since 2015, had a new $450,000 home equity loan taken against it, signed using the power of attorney, with the funds transferred to an account Gerald controlled. Patricia, still managing chronic pain and limited mobility throughout this period, noticed small things that troubled her, but that she could not fully process. A retirement account statement that arrived showing a balance far lower than she remembered. A mortgage statement for a loan she did not recall discussing. Gerald's explanations were always immediate, always reasonable sounding, always delivered while she was tired or in pain. By June 2022, Gerald had liquidated the remainder of her retirement portfolio across several smaller transactions designed to stay below thresholds that typically triggered additional bank verification. Total transferred, $1.8 million. In September 2022, Patricia's daughter, Rachel Mercer Diaz, flew in from Seattle for an extended visit after Patricia mentioned during a phone call Gerald had not been able to fully monitor that she felt confused about money not adding up. Rachel took her mother to the bank the following week. The retirement account balance was $14. Patricia sat in the bank office and could not, for several minutes, form a complete sentence. Rachel asked the bank manager to print every transaction from the previous 18 months. What they found was a power of attorney document Patricia had no clear memory of understanding. Dozens of large transfers she had never knowingly authorized, and a pattern of timing that placed nearly every major transfer within days of a medical procedure, medication adjustment, or documented period of impaired mobility. Rachel contacted attorney Susan Marlowe of Marlowe Elder Law in Phoenix, who specialized in elder financial abuse cases. Susan Marlowe reviewed the timeline for less than an hour before she said, "This is not just a divorce case. This is elder financial exploitation under Arizona law. We are going to need your surgeon's complete medical records, including every medication administered around the date this power of attorney was signed." When Gerald was confronted, first by Rachel and then by Susan Marlowe's formal legal notice, his response was immediate denial. He insisted Patricia was fully competent and willing throughout every transaction. He refused to voluntarily relinquish the power of attorney. Susan Marlowe filed for emergency revocation of the power of attorney and a full forensic financial audit within the same week. The court granted both within 5 days. The case was heard before the Honorable Judge Diane Carmen Ruiz at the Maricopa County Superior Court, Family and Elder Law Division in Phoenix, Arizona. Docket number 2022 PB 2207. Proceedings began in February 2023. Susan Marlowe's case rested on a single devastating piece of medical evidence. She subpoenaed the complete operative and anesthesia records from Dr. Howard Bennett, Patricia's spinal surgeon, documenting the exact medications and dosages administered in the 20 minutes before Patricia's surgery, the same 20-minute window in which the power of attorney had been signed. Dr. Bennett testified that the sedative administered at that time was known to impair short-term memory formation and judgment for a minimum of 2 hours following administration. He testified that in his clinical opinion, no patient under that level of sedation could meaningfully understand or consent to a complex legal document. Gerald's attorney, Thomas Whitlock of Whitlock and Pierce, argued that Patricia had discussed and agreed upon the power of attorney verbally weeks before the surgery, and that the signing itself was merely a formality. Susan Marlowe asked one question that ended that argument. "Mr. Voss, if this was discussed and agreed upon weeks in advance, why was the actual signing scheduled for 20 minutes before sedation, rather than at any point during those weeks when your wife was fully alert?" Gerald did not answer. Judge Ruiz asked him to answer the question directly. He still did not answer. Then Susan Marlowe introduced the bank's own internal fraud detection log, showing that an automated system had flagged 3 of Gerald's transfers in 2021 for unusual patterns, and that Gerald had personally called the bank each time to manually override the flags, identifying himself as power of attorney holder, acting on his wife's behalf. The courtroom did not move. Judge Ruiz looked directly at Gerald and said, "You did not simply take advantage of a moment. You built 18 months of careful financial extraction around her vulnerability and called the bank yourself 3 separate times to make sure no one stopped you." On April 3, 2023, Judge Diane Carmen Ruiz voided the power of attorney retroactively to the date it was signed, ruling that Patricia had lacked the legal capacity to consent at that time. She ordered the full restoration of all transferred funds and property, totaling $1.8 million, plus an additional $300,000 in damages under Arizona's Elder Financial Exploitation Statute. The Maricopa County Attorney's Office filed criminal charges of financial exploitation of a vulnerable adult and forgery. Gerald pleaded guilty in July 2023 and was sentenced to 6 years in the Arizona Department of Corrections. His financial planning license was permanently revoked by the state board. On the day the ruling was issued, Patricia stood outside the Maricopa County Courthouse with her daughter beside her. She did not say anything dramatic. She said, "I think I'd like to go see my old classroom. I haven't been back since I retired." She spent 31 years teaching children that trust, once given honestly, should never be exploited. The man she trusted most learned that lesson in reverse. Gerald Voss did not simply take advantage of a vulnerable moment. He built an entire system around it, timed to every surgery, every medication, every moment her body was too tired to ask questions her mind would have asked if it could. But Patricia Mercer raised a daughter who asked questions when her mother no longer could, and the law eventually asked the only question that mattered. If your aging parent signed something they do not remember signing, would you know how to find out what it really said? Tell us in the comments below, and subscribe to Divorce Diaries for a new divorce court drama story every single week. Because trust should never require recovery from anesthesia to be exploited.